So human rights as law. Why do we have this lecture as the starting lecture in the week? Well, it's because that most of this week will deal with human rights as law. And so we want to explain what does that mean to have human rights as law, and why are we focusing on law? And you see a lot of law. Oops. How did I?
You want to move ahead?
Yeah. Oh, there it goes.
Yeah.
Oh, I guess I have to move only the mouse. Okay. You see a lot of law, or you see a lot of people talk about human rights all the time. And they say human rights is this and human rights is that. Well, there's different meanings behind what they mean by human rights. And so there's this human rights as philosophy, as moral norms, this human rights as revolution, as liberation theory or destruction of hierarchies. And some say, well, human rights are just rhetoric, it's just a political tool, it's politics put into some other words. And then there's law, and that is what we want to talk about here. That's what this lecture is about. Human rights as law. If I X that, will it?
Just to take it down. Oh.
Because every time I go to forward it, it then
Okay,
pops back.
close it then. Close it.
Oh, we'll see. Yeah, it stays there. Okay. Sorry about that. So this lecture is about law. And when you hear people talk, you hear about in the United Nations, in fora, people say, oh, this human rights, and a lot of times they're bouncing all over the place. They're not focusing on what they mean by human rights. And so this lecture here will talk about what we mean in most of the rest of the course about human rights and why we talk so much about law. There. So what are human rights? What is law? When we talk about law, we'll start with that, a very fundamental question. What is law? Well, law says, there's a positivist theory of law that says we separate law from everything that's not law. And when we talk about law, that's what is. That's what's agreed upon. And everything else, that's not agreed upon. And so to give a good idea about why law is so important in human rights, you can refer back 500 years to a debate that happened in Spain. And the context of it was there was the discovery of the so-called New World in the Americas. And the king of the Holy Roman Empire, Holy Roman Emperor, he didn't know what to do with the people who lived there. And so he called a formal debate, and he asked people to come. And on one side was Juan Sepulveda, and he made the moral argument that the people of the so-called New World were barbarians, and therefore they were natural slaves. He made this from a moral argument. And on the other side, Bartolomé de las Casas, he made the moral argument that no, all human beings have dignity, and therefore they should be entitled to equality. What happened after the debate? This debate went on for about 2 weeks, very formal, going back and forth, and kings listening, big reports being made. Afterwards, both sides claimed that they had won, and nothing happened, because there was no ability to decide who wins the moral debate. And we see that today in all kinds of fora. People argue back and forth, this is what I feel, this is what I mean. But yes, everybody can have different meanings, everyone can have different feelings, but when we decide on what is law, then we've decided on a foundational basis on which we all can at least agree on some fundamental principles and move forward from there. We might argue about those fundamental principles, but at least we've sort of cut away a lot of the other issues and tried to focus the arguments a little bit more. So when I say that law is separated from what is not law, I just want to make one caveat to that, that law is not so divided. There's soft law and hard law. I'm sure you've probably heard the term soft law, hard law. So somewhere when we start to get into law, hard law are the things that we can say, okay, we can point to a statute, a treaty, and say, yes, this is law. But then there are other things that sort of affects law, and that's sort of a gray area in between what is not law and what is law. We'll get into that more a little bit today and throughout the rest of the course. But just as an example, the Universal Declaration of Human Rights, when it was first adopted in 1948, it was very much soft law. It was and maybe not even that, maybe just a moral declaration. And it was a UN General Assembly resolution, which does not have binding character, so it's definitely not hard law. But over time, its adaptation into domestic systems has brought it closer and closer to hard law. So some argue today that it is very much hard law. So you can see how there's a gray area in between what is law and what is not law. So what is human rights law? Why do we have human rights law? Well, if we use the way that Asbjørn Eide from the Center for Human Rights here has described it, there are three phases to human rights. The first is idealization. It's the conceptualization of certain things that we think are good, norms, ideals. And in order to achieve those ideals, we use law. So law is a tool. Law is a mechanism to get from these ideas that we've had to actually enjoying those ideas. And what Asbjørn said was it's very much a structural approach. Law is a tool. It's a mechanism to get from one place to the next. If you will, if you're familiar with the movie The Wizard of Oz, law is the yellow brick road. We start when we arrive in Oz with certain ideas about human rights generally, and the law, we design human rights law as a road to get down to the enjoyment of human rights. But just as an example, when I say idealization in this phase 1 of human rights, an example that is often referred to, human dignity as a fundamental foundation of human rights. You see human dignity in almost all of the human rights treaties and the preambles. It talks about human dignity as sort of a fundamental basis of human rights. The ideals that we're starting from, and law is then to achieve those ideals. And we see this in the United Nations Charter. It says in the preamble that one of the reasons for the Charter is to reaffirm faith in fundamental human rights and the dignity and worth of the human person and an equal right. So we have that human dignity, we also have equal rights. That's the ideals behind the Charter. And then the Charter starts the law. So this what we call this human rights system, human rights law, starts in 1945 with the UN Charter. There were some attempts beforehand. The ILO, International Labor Organization, started in 1919. And of course, the League of Nations attempted something along the lines of the United Nations beforehand. But our modern system starts in 1945 with the UN Charter. So I'm going to talk now a little bit about what this human rights system is, this legal system that we've created. So 3 years after the Charter, we have the Universal Declaration of Human Rights. And in the preamble, it says exactly what this human rights system is. It is a common standard of achievement. Now, remember when I said how at the beginning we had all these morals and all of this different ideas that people had, and law tries to focus that, to narrow that down into something more agreed upon. That's exactly what it says here in the Universal Declaration, that this is a common standard of achievement. Now we say when we say a common standard of achievement, often you hear claims of the universalness of human rights. And the Declaration itself says it's a universal declaration of human rights. We think of all of these circles as different worldviews. We have to realize that there is no one overlapping place that we can say, yes, there is a universal moral basis of human rights. There's just simply no single overlap that we can say is universal. But what the Declaration does is says, okay, yes, people have different moral claims. People have different moral conceptions of what human rights might be. But when we have law, choices are made. Certain parts of those worldviews are chosen out specifically and are incorporated into law. That narrowing down of a massive, unending worldviews into something more focused and more easy to handle. So in 1945, as I said, the UN Charter was adopted, and then starting in 1969, the Convention for the Elimination of Racial Discrimination was our first really hard law in human rights law. And then in 1976, entered into force the two covenants, completing what's called the International Bill of Rights. The Universal Declaration and the two covenants are considered the Universal Declaration of the International Bill of Rights. And that is the foundation of our hard law and the choosing out of certain elements of the worldviews into law. That is not to say that law cannot be criticized. There are certainly many claims that can be made, very good claims, to say that the choices that were made were not good choices, or the choices that were made did not cover the entirety of human rights, and there are holes in the human rights system. And yes, there are many holes in the human rights system, and there are many flaws in the human rights system. And these are just some examples of some of the claims that have been made. Hannah Arendt, all the way back in 1948, famously claimed that this system, by relying on states, had a structural issue because people, if they weren't citizens, they didn't have rights. And so rights were based on citizens, and that's not what human rights is, she said. And a more recent claim about Asian values, that these choices that were made are more Western European values. Those might be good claims. I won't get into them here, but the point I want to make is that those are issues that are taken about what the law ought to be. It doesn't really affect what the law is. We have the law as we have it in the treaties, in the decisions that have been made thus far. You can certainly argue about that those were not necessarily good decisions, but we have to distinguish between the arguments about what the law ought to be and what the law is. And if you will, if the other movie reference to the Wizard of Oz is too old for you, maybe a more modern movie, The Matrix, if you want to conceptualize the law as a matrix. It's a socially created thing. As Jeffrey Hazard has said, law is a non-utopian social construction for controlling social conflict. So it's not perfect. It's created. It's a social construction like a matrix. And it's just, the purpose is to resolve social conflict. So I want to distinguish two things in this human rights system. There's human rights as, in the human rights system, there are substantive standards and there are structural standards. Now, the other lectures throughout the week will focus more on these substantive standards. They'll get into what does it mean to have a freedom from something? What does it mean to have a right to something? So, for example, on Wednesday, when I talk to you about economic and social cultural rights, we'll talk about perhaps the right to health or the right to adequate standard of living, and we'll try to get into the substance of what those are. And so I'm not going to do so much on the substantive standards right now, but I want to look at the structural standards to see what it means when we talk about human rights as law, when we have that common standard of achievement. This is a conception that you see quite often, that the relationship between states in international relations is a horizontal relationship. And there's sovereign equality, as it says in the United Nations Charter, between the different states. And it's between the states where this law is created. When these international treaties were adopted, it is the states that adopted them. So the human rights law that we have is created between states, but it's for the benefit of individuals. So it's an agreement between states that governs the relationship between the state and the individual. It's been called a vertical relationship between state and individual. I don't particularly care for these terms, horizontal and vertical relationship. I put them up here because that's the way it's normally used in the literature, but I don't like the idea of a vertical relationship with the state over the top of the individual, because I think that really undermines what human rights actually is, that the individual has certain power and worth in themselves. But from a legal perspective, yes, this is the way it is. The state is the what's called the duty bearer, and the individual is the right holder. But this human rights system created by law does a lot more than just that. And these parts might be the most important parts of the human rights system. Now, on the one hand, it enables it makes it lawful and not a breach of sovereignty for international organizations, for the UN, for states to keep an eye on this relationship, this vertical relationship. And on the other hand, individual-based organizations, both individuals, NGOs, treaty bodies, they also are given a place at the table. They have the legitimate ability to examine this vertical relationship between the state and the individual to make sure that the state is upholding its obligations and that the individual is receiving their rights. And I'll talk a little bit more about these binoculars, these legitimized viewing of this vertical relationship. And this is what's so important, I think, about the human rights legal system, is it replaces these with binoculars, what used to be swords. Before, when you had arguments, when you had social conflict was resolved through power. And now social conflict is resolved through something else. And we'll look at what that something else is. Just mentioned that the positivists, the positive legal theorists would say, yes, this is very good. Law is a procedural paradigm. It creates procedural structures. Before I get into those binoculars, I just want to focus one more thing about the nature of state obligations, that vertical relationship between the state and the individual. Also, Asbjørn Eide has come up with this conception. Also, Henry Shue wrote something as well on it, of respect, protect, fulfill. Human rights obligations are obligations of states to respect, protect, and fulfill human rights. So respect means that a state is, don't bother the individual, leave the individual alone. And protect means that the state has to protect the individual from other individuals who might want to harm them or do something to disturb their livelihoods. And fulfill means that the state has to deliver certain things to the individual, to provide the necessary conditions for them to be able to enjoy their human rights. So for example, if we look at the right to life, for the state to respect the right to life, the state should not kill someone. And for the state to protect the right to life, it should protect individuals from killing other individuals. And for the state to fulfill the right to life, it needs to have the conditions that prevent risks of death. I thought I would just mention, and we can't get into this very much today, but we'll get into this in many of the lectures throughout the week, that the objective of all of this, we have to keep in mind, is the realization of human rights, the enjoyment of human rights. And I just put up some of maybe the more fundamental human rights. Of course, all human rights are equal, but some we can point out are very much fundamental: the right to life, equality, adequate standard of living, health. These are all very important rights, as all of them are. And the realization of human rights is not necessarily just to keep people alive, but it moves forward. The thresholds continues to move forward to a better and better enjoyment of human rights. We'll look at that graph there, that chart, a little bit more on Wednesday. But I just want to point out that realization, what the law is aiming for, is it's aiming for the entire enjoyment of human rights, not a minimum, but really a maximum, the full enjoyment of human rights. So I've talked a lot about human rights as law, but where does that leave us then? Does that mean that the fate of human rights is in the hands of lawyers? And is that something that we really want? Lawyers don't always have the greatest reputation. And this is where I come back to those binoculars, how important those binoculars are, because those binoculars, the ability to keep an eye, that legitimate ability to keep an eye on the vertical relationship between the state and the individual, belongs to many more than just lawyers. It's not just a legal system, it's a legal system that creates a place for practically everyone. So we're quite aware of, when we talk about human rights, the International Court of Justice, the treaty bodies, the regional courts, we always refer to these cases. Everyone sort of thinks about human rights when they think about these organizations. And in the individual countries, of course, the Supreme Courts, the whole court system is often dealing with human rights. Those are things that we see all the time. But also in political space, there are mechanisms that are created to be able to decide these issues. Remember when we go back to that debate 500 years ago, and they both debated the moral issues, there was no mechanism to decide. There was no mechanism to say, okay, here's how we resolve the social conflict. Here's how we move forward. We have mechanisms in the international system for moving forward. And we have both interstate mechanisms, we have individual people, we have specialized agencies, multilateral organizations, all to have a place for examining that vertical relationship between the state and the individual. Of course, parliaments do the same thing, the various parliaments in each country. And I put up pictures here about fights going on in parliament because I want to emphasize that, yes, law is there to resolve social conflict. That's why we rely on the law, but it doesn't mean that social conflict completely ends. There are plenty of conflicts that continue, including physical altercations in parliaments. Little historical tidbit. If you look at the picture there of the United Kingdom Parliament, and you see two red lines on the green carpet, the distance between those is 2 sword lengths. And so during the debates in Parliament, each side was not to cross the line, and the Speaker of the Parliament would say, toe the line whenever someone would come near it, because you want to stay behind it so you didn't kill each other. So in addition to all of these larger institutional organizations that we're familiar with in human rights, there is this human rights system creates legitimate space for, even at the individual level, to keep an eye on and to criticize, if necessary, this vertical relationship between state and individual. So NGOs have a legitimate ability to do so. Individuals also have a legitimate ability to do so, and have affected the system quite greatly. As we see in many social movements that have happened, so most of the most significant social movements in the past, since the human rights system began, have been individual-based. And so it all comes down to, it coalesces to this system for taking all of these different claims and putting them into some sort of structure that we can have a debate on a common standard of achievement. And we have mechanisms that eventually decide an outcome so that social conflict can be resolved. As an example here, in the Iraq War, prior to that, in the UN Security Council, a case was made about why the US wanted to invade Iraq. There were individuals who opposed it, and probably was an illegitimate decision of the United States to start this war, but we had a decision was made. We had, something, society was able to move forward. And what's very important is, even in this case where the United States invaded another country and started a war, we have all of this was able to be discussed. And so it came very much to a point about that the United States was probably wrong, and an acceptance of that point. And I think that the effect that that's had afterwards is very important to look at. We can't look at all of that right now, but the way, even when issues maybe are not decided in retrospect, as we see as probably would have been the best way, we have a system by which we could probably learn from our mistakes. And so this democratic space is really to do just this, to change the world, to make, to come to conclusions and move forward in ways that are peaceful, to avoid ways that are violent. And I have to emphasize again that that doesn't mean that there's not going to be social conflict. There continues to be social conflict. But at least we have a mechanism by which to reduce social conflict and to reduce the uncertainty and the inability in some cases to come to resolutions of issues. So just to put it in contrast, if we look back in time, 2,500 years, there was no mechanisms. There was no foundational aspect of law or human rights law. In this case, this was the island of Melos was an independent island, a neutral island, and the Athenians, they invaded it, and Melos declared that we are just men fighting for unjust, and we invoke what is fair and right. And the Athenians responded that you have mentioned nothing which men might trust in and think to be saved by. The strong do what they can, and the weak suffer what they must. And the human rights system puts in contrast that, well, this may not be the way it is anymore. That it's not that the strong do what they can and the weak suffer what they must. You could look back at say, the Iraq War and say, well, the strong, the United States did what they wanted, and the weak suffer what they must. But there are norms, there are legal norms that are able to restrain the state in what they're doing so that the weak do not necessarily suffer what they must. And while this example was 2,500 years ago, we had a similar example just a little more than 75 years ago when Nazi Germany invaded Norway. And there was a discussion between the two individuals here in Norway, the Minister of Defense and the representative from Germany. And the Minister of Defense said, you know, we're going to stand for what is right and we're going to protect our independence. And the German representative famously said, nothing can save you. There was nothing to rely on. There was no law to rely on. Now, I've talked all about these NGOs and the way individuals can affect the outcome of things and have a place at the table. But you really have to understand that you have to understand the whole picture here. You have to understand that individuals alone, often in reality, will need the help of states. You have to use the whole system. So Jody Williams, she won the Nobel Peace Prize for her work on the international campaign to ban landmines, a very effective individual campaigner, but she knew the realities of the system, and you have to rely on and get the support of the other parts of that system. So she said, if you think that singing and looking at a rainbow will suddenly make peace appear, then you're not capable of meaningful thought or understanding the difficulties of the world. So while this human rights system leaves place for the individuals, you have to realize that the world is a complex place and you have to use the whole system, including the states, to achieve meaningful change. What are we doing for time?
We are now, yeah, we have 12 minutes more.
12 minutes more.
We also received one question.
Yes, we have a question.
From Joyce.
Yeah.
And your.
Yeah, if you could just. Maybe Joyce could say.
Joyce, did you have a question?
Regarding duty bearing.
Yeah.
It's unmute.
Oh, should I just say
Yeah,
TM?
go ahead, Joyce.
All right. I just wanted to ask or clarify regarding duty bearers, because usually it's identified as the state, but is it only just the state? And if not, then how do I identify a duty bearer?
Yes, that's a very good question. Uh, you'll get a more full answer on Friday when you have business and human rights. But from the hard law perspective, the only duty bearer in the human rights legal system are states. So it is the states that have all of the duties and obligations toward individuals. You'll see in the Universal Declaration and other places where it does remind that individuals have certain responsibilities. So there are responsibilities toward other individuals. And I think in the Universal Declaration it says every organ of society. So there are certainly recognized responsibilities throughout society, but the duty bearers formally in hard law are states. Having said that, on Friday, you'll get a little bit more nuance in the soft law. That's expanding out into other organizations like businesses.
Within the national legal systems, of course, you will have many obligations on individuals, but these are not, regulated by international law, but by the national legal systems.
Yes, very good point that Axel just made. That what I'm talking about is the international human rights system. So national systems may have slightly different formulations.
Okay, thank you.
Okay. So in the time that we have remaining, I just want to talk a little bit about how to wield the power of this human rights system. And there are two things you need to know fundamentally, are sources of law and how to interpret those sources of law. So in the national system, we're all familiar with three branches of government, executive, legislative, and the judicial. And that's where we get most of our law, through statutes or through cases or through executive regulations. Yes, Montesquieu says that's a very good idea with three branches of government. In the international system, it's a little bit different. The domestic system, individuals mostly create the state and elect the officials. The state then makes laws. Some of the laws govern individuals. In the international system, the laws are made by the states themselves through consent. And so the only laws that exist in international law are those that states have consented to. There is something called jus cogens. I won't get into that, but I'll just mention it. But so it would be as if in the domestic state, in each national state, that each individual walking around on the street would be able to say, well, that law doesn't apply to me because I haven't consented to it. That's the system that we have in international law, what's been called the volunteerist approach. So where do we find international law? If we look in the statute of the International Court of Justice, Article 38, it says that there are three primary sources of law. There are conventions, there's custom, and there are general principles. There are some subsidiary means, but these are only ways to interpret the primary means. You can't get law directly from judicial decisions or teachings of the highly qualified. Yeah. Just a comparison between international law and domestic law. You can look that over when you get the PowerPoint. But this is an important, and maybe we might run out of time at the end of this, so this would be a good place to end. But it's important, all of this human rights system that I've said of what the law is. And I've said that, this hard law, that's what we rely on as law. And nothing else is law. But when we do that, are we saying that law can solve every question? If you have a human rights question, does law solve the issue every time? Well, on some occasions, like if you ask the question, is the death penalty a legal punishment for being gay? If you look at the legal matrix, the international law, there's an easy answer to that. There's one answer, and the answer is no. No, that's not a legal penalty. If you have maybe a more complex question. Is there a right to free universal health care? Some would certainly argue yes, and there certainly is a trend toward that. But if you look at the legal matrix, all of the law that we have, there are a number of different answers to that question. There are competing answers. So while I've said this whole time that the purpose of law is to solve social conflict, it doesn't mean that it reduces every question to just one answer. There are competing answers. But this is also what makes international law and human rights very exciting, because it leaves it for the lawyers, the people who can make the good arguments, why one of those answers is a better answer than other answers. And in legal theory, this is called indeterminacy.
We have some more questions.
Okay.
If you would like to.
Yeah.
Maybe ask the people posing the questions directly.
I asked her to unmute.
Hello.
Hello.
So,
Hi, Sema. Go
Hi.
ahead.
Hi, Dr. Ostad. It was a very, very lovely conversation. But talking, I had a few questions and thoughts running through my mind.
Yes.
The first thing that came to my mind was where I live. I live in Africa, and for us, and that's the first question, and you ended it well with the right of that word indeterminacy. That was my first time hearing that word, and how we've had conversation over varying standards of human rights in Africa. So for instance, we're talking about development and the environment, and we've had conversations here in Nigeria where Europe is moving away from coal, Europe is moving away from certain things to protect the environment. And here in Africa, the conversation is on why are they stopping us from mining coal for development? And so the question now comes to what is right and what's, while there's a right to development, there's also a right to protect the environment. So where do you now draw the line? Do you understand what I'm trying to say? And so these conversations happen. And so it's sometimes it feels like Africa is not carried along in the context, because there's the ideal, like this is the standard we should aspire to. But Africans feel, oh, Europe is already here. You don't want us to get here. And so you're telling us don't mine coal, for example. But of course, we know how dangerous coal is for the environment. We know how communities suffer from coal. But then we do not have the infrastructure to protect communities from extracting coal, or as the case may be, coal is just an example. So so my question will be like, is it fair to say that human rights standards vary according to communities? Certain standards are basic, certain standards are minimal, right to dignity, everything with dignity underlying makes sense. But when it comes to things like development, environment, universal healthcare, Africans tend to argue that why should the same standards be set for us when we don't have the same level as development as other climes, especially the West? So that was something that I was just thinking about, and it's something that has always boggled my mind. Where do we draw the line? What are the standards? By what standards should we measure Africa? Should Africa be measured on the same standards with Europe? Not with certain rights like right to life, certain rights, the non-derogable rights, but all those other conversations around universal health care, rights to livelihood, those kind of things. Where do we draw the line? It would be interesting to know what your thoughts are, what everybody else thinks about that.
Yeah, I'll answer that question more fully on Wednesday. We'll deal with that almost exclusively on Wednesday on economic, social, cultural rights. But I'll say now that when human rights has certain standards, and particularly in issues like development or poverty eradication or the environment, those standards are what's called obligations of conduct, not necessarily obligations of result. Maybe I'm getting into this a little too early because you need a bit of preliminary information before we get into that on Wednesday. But when a country is attempting to develop, then there are not hard and fast. When you look at hard law, what does the hard law say? The hard law does not say that a state must achieve a certain high standard of living immediately. And if it doesn't achieve that, then there's a violation of human rights. Human rights does not say that. There's an obligation about a minimum standard, what's called a minimum core, that has to be achieved where people are not dying, basically. But when it comes to development or the environment, those are not, from hard law, those are not things that there are obligations to achieve a certain result immediately. That might be a little vague answer, but it's going to take a long answer. And seeing we're going to do that on Wednesday, I won't spend too much more time on it today. But I just want to also emphasize that that human rights is contingent on each state. There is not a single standard on each right that can be applied universally. It has to be an examination of the particular context in that particular situation, and how can human rights be best fulfilled? How can that enjoyment be achieved in the best possible way in that particular circumstance? And those are also international obligations between states. So one state cannot be sitting back and saying, well, in Africa, they should not be mining coal because that's bad for the environment as a whole, and we can afford that. Well, if other states can afford that, there's an obligation in economic, social, cultural rights to international assistance and cooperation, which would say that there should be assistance if there's a requirement, or if some states want the environment to be as clean as it possibly can be, they should assist and cooperate for states in achieving that objective. But we'll come back to that on Wednesday in great detail. You've hit exactly on the whole theme, basically, of the economic, social, cultural rights lecture on Wednesday.
Yeah.
But before we end, or we have any other questions, I just want to finish the one last slide here, or this one and the one after it, to just emphasize how I've talked about human rights being this legal system, and I've talked about it being this matrix, and you basically have to stay inside the matrix. You have to stay inside the law. And when you talk about human rights, to focus on the law, the law, the law. But we have to realize, as I just said about this indeterminacy issue, that the law does not necessarily have all the answers, and that we cannot abandon the moral issues that the law is based on, the idealization of what the law is based on. And we have to recognize that the law has certain limitations and it has certain holes. And I'm going to show the next slide, and I apologize if it's a bit shocking, but I think it's important to face the holes that the law has. The law has some major holes. That poverty in many regards, in many places in the world, remains legal. That the legal puzzles that we have do not solve these issues. That refugees, for example, that it is legal that states keep them out, and people attempting to simply have a better life or to survive, including children, die attempting to reach other places where they can simply have a decent life, or that people die where they are because of poverty. And so the law has certain holes, and when I say that human rights is law and then we have to deal with it as law, everything cannot be just conceived as a blinded legal puzzle. Yes, and then the rest of the presentation you'll receive, and so there'll be more detail in the presentation about how, what are conventions and how do we determine what is a convention, how do we determine what is a treaty, what is custom, how to determine custom, and the general principles of law, how do we determine that. So take a look at the PowerPoint afterwards for more of the detail work about what these customs are, where to go and find them. So that ends the presentation. I don't know if we have any more.
No, we do not.
Oh, and 3 minutes over, I'm sorry. We'll say that 3 minutes was from the technical issues at the beginning.
Yeah, that's probably true.
Yeah. But they have a break now for 15 minutes?
Yes, thanks a lot, River. We will have a break now until the next presentation starting in 12 minutes from now. You are free to stay in this forum until then. You're also free to go. There are some questions I assume that has not been answered yet. We will look through them afterwards and either reply you directly to the questions, or they will be addressed in later sessions.
Would it be okay if I don't want to disturb somebody if they feel like they want to get up and get something to drink, but during the break, I'll also be here if somebody wants to ask any questions.
That's great.
Or something. But there's no pressure. People don't have to stay. It's just like if we were all meeting together here in the room and everybody got up and some went to get a drink and others came up to chat with me. So feel free to have any discussion during the break.
Yeah, you might want to look at the chat if you want to address the questions.
Okay, yeah.
Hello.
Hello.
Hi, Prof. Can I ask a question?
Sure.
So just to piggyback on Yvonne's question, with regard to state obligation, how do we argue as human rights lawyers and activists in case of states giving prominence to cultural and religious sentiments that automatically derogate or infringe upon individual rights, which are a general principle and customs within the universal human rights principle? So what would be the argument? Because I mean, of course, this brings us to universalist and relativist conversation, but I would like to know your take on that.
So your question is about state conduct when it violates or human rights or derogates from human rights?
Yes, to safeguard religious and cultural sentiments.
Yeah, safeguard religious. Yeah. Yeah. Of course, every time I get a question, I sort of want to answer it in about 5 or 6 hours of discussion. But in a very short answer, states do have an obligation to change social norms in certain circumstances. When social norms violate fundamental individual rights, a state has an obligation, the obligation to protect an individual from other individuals, even if those other individuals are acting according to the social norms, either religious or cultural norms, that the state sometimes has the obligation to change those religious or cultural norms. Now, having said that, there's definitely the base position that states should respect social, religious and cultural norms, should respect these norms. And the state should not get involved with trying to change them because the state thinks, oh, that we don't like that. That's old fashioned, or that's people who do that are just poor, and we don't like that. We want to change it. So there's the state's primary obligation is to respect religious and cultural norms. But when they violate someone else's individual rights, then the state has an obligation to step in. One good example of that has been pretty much universal condemnation of in all of the international human rights mechanisms is female genital mutilation, that while that might remain a religious or cultural norm in some places, there is an obligation of the state to intervene and to prevent that from happening because of the rights of the individual girl child. That's a short answer on a very nuanced question where the threshold between the obligation to respect religious and cultural norms and the obligation to step in and change them is very vague and very fine. But the short answer, we'll have to leave that for now, but we can discuss that more as well. I'll actually come back to that a little bit on Wednesday too.